Altman, Poindexter, Wyatt.
I have heard those names before.
Well, they have great advice, and they've been on the show before.
I agree. I agree.
Oh, alternative dispute resolution is the topic
If
for
we
this
weren't
morning.
agreeing, then they would be able to help us.
Paul, I don't think we've ever had a dispute that I...
But just in case.
Just in case.
We know the people.
And can you kind of identify what the difference is between arbitration and mediation?
Well, there are a few primary differences. One of the biggest differences and misconceptions is that in mediation, it is a third-party neutral that really is attempting only to facilitate an agreement. So, in other words, they're not making any decisions. It's not a judge, it's not a jury, it's not a person that's making decisions. They're really only trying to help you and the other side reach an agreement. Arbitration, which is usually binding arbitration, is a third-party neutral who's making a decision and then telling you and the other side the decision. So that's the primary distinction, is decision versus facilitation. Indiana adopted rules quite a long time ago which allow for alternative methods of resolving those disputes.
Yes.
And we have 5 methods. The most common methods are what we just talked about. They're mediation and they're arbitration. The third, probably most common method in Indiana out of the 5 is private judging. So you can go and literally hire a former judge and have them be the decision maker in your case. You know, one of the reasons clients don't like going to court, out of a number of reasons, but one of the reasons they don't like going to court is that our courts are very busy and it takes a long time to get a hearing date. And then it takes a while to get your decision. So if you can hire a former judge and get a quicker hearing date and a quicker decision because they don't have a backlog of 1,000 or more cases, then that may be very good for them. So that's the third most common method.
Many trials aren't really used a lot.
No.
Yes, so it would be mostly that arbitration, mediation. I'm looking at ways in which a consumer or an individual could appeal to their lawyer and saying, listen, I want to go this pathway. I want to avoid, say, a trial, maybe to save some money. And looking at it from the standpoint, if I don't have any kind of contract that states that I need to go to arbitration or mediation. Yes.
So those are 2 really good points. At any time during the case, a client can always say to their lawyer, you know, let's explore the possibility of going to mediation. Let's talk about the possibility of arbitration. The majority of cases that go to mediation settle. It is a good process. It is a worthwhile process. Not every case settles, but the majority of cases that go to mediation settle.
The mediator can be a nice referee.
And there's, you know, something about the process and people getting together and being able to tell both stories and working through it at the same time in real time, not letters, not even emails going between the lawyers, but all being engaged at the same time in the same facility and getting through it and being done, having resolution. And it's a process that works the majority of the time.
Oh, very good. And thanks for having us.
Thank
being
you.
here and explaining all of these different methods to resolving disputes. I'm Kevin Kimbrough, Boomer TV.